next case to come before the court is Haley Dietrich v. Daniel A. Core et al. Are both attorneys present?
Yes, Your Honor.
Yes.
You may proceed then to the table. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please introduce yourselves, keep your voices up, remain behind the podium. You should not use the names of children or minors or victims during your argument, although you can refer to those folks by initials or terms like the child. We have read your briefs and are ready to proceed when you are. Would you like to reserve time for rebuttal?
Yes, 5 minutes.
Very well. You may proceed when you are ready.
May I please the court? My name is Bradley DeBoeuf. I'm an attorney for the appellant, Haley Dietrich and Elizabeth Dobbins. The first order that we've appealed from is the May 29, 2022 order that denied the plaintiff's motion for default judgment. That order also granted the appellees, the defendants in this case, their motion to strike and request for sanctions pursuant to Civil Rule 11 and Revised Code 2323.51. The defendant's motion to strike was based on the plaintiff's prior motion for default judgment. The reason why the plaintiffs filed their motion for default judgment is that after the individual defendant, Daniel Core, was served with the complaint, the defendant filed a motion to stay and refer the matter to mandatory arbitration. They didn't file an answer to the complaint. They didn't file one of the enumerated responses under Civil Rule 12 to respond to the complaint. There was no request for a temporary restraining order by the defendant. There's no preliminary injunction. There's no request under Civil Rule 6 for an enlargement and extension of time to file an answer, nor was an automatic leave to plead filed under Local Rule 7.13. At the time that the court entered this May 29th order, no determination had been made yet that under Revised Code 2711.02b that the court was satisfied the action is referable to arbitration, nor had an order been entered at that time that the action had actually been stayed. The court had doubts at that time, May 29th of last year, whether the case should be referred to arbitration and ordered additional briefing on that issue. That was the additional order also issued on May 29th. There's no statute, no civil rule, or case law that was cited for assessing sanctions in the order. The May 29th order regarded the motion to stay and request for arbitration is effectively tolling the case, and there was no basis for the motion for default judgment. The court assessed sanctions of $150 against Attorney Dietrich for filing that motion for default, and it was also ordered that she be paid that within 30 days of that May 29th order. At the time that that order was issued, the appellees had requested this matter be stayed and referred to arbitration. However, at the time of that May 29th order, the court had not determined that it was satisfied that actions referable to arbitration.
Counsel, just so I get this timeline correct, when that motion to stay was made, is it your argument that the appellant didn't know that the motion to stay had been made? Because didn't she prepare and file the response to that motion the same day as the motion for default judgment?
Yes, yes. In the appellant's motion for default judgment, they did not mention that motion to stay. When the court imposed sanctions in that May 29th order, we have no idea under what grounds the court imposed sanctions. Was it under Civil Rule 11, or was it under Revised Code 23.51? There's no mention of willful.
The motion for sanctions that was filed by the appellee in this case, did it specify under the statute or the civil rule which one was asking for sanctions under?
Both.
It would ask for sanctions in both?
Yes, yes. Yes, and the caption in that plea doesn't mention that there are requests for sanctions under Civil Rule 11 and Revised Code 23.51.
Thank you.
That May 29th order, there's no mention of the word frivolous in that order, that there was a determination under Revised Code 23.51 that motion for default judgment was frivolous. Case law is clear that before a court awards sanctions of attorney's fees under Civil Rule 11, an evidentiary hearing must be held. That hearing is mandatory and statutory under Revised Code 23.51. There's an Ohio Supreme Court case, Davis v. Metzger, 2014 case, that was cited in our briefing. In that case, the Ohio Supreme Court held that the Court of Appeals was required to conduct a hearing before determining the party had engaged in frivolous conduct. That case was remanded to the Court of Appeals for the required hearing.
That under the statute or the civil rule or both in that case?
The statute. At least the statute. The opponents have cited several cases that a two-step process needs to be used by a defending party before the matter is referred to arbitration. One is the party needs to move for a stay. The second step is to file a responsive plea or file an answer to the complaint. Attorney Dobbins faced more sanctions in this case if she didn't pay the contempt within. She faced more sanctions, contempt if she didn't pay that $150 sanction within 30 days of that May 29th order. She also faced potential sanctions again if she moved for default against the other non-answering defendant, Canvas co-worker. This case was brought as a civil action, not initially as a statutory proceeding. The court essentially converted civil action into a statutory proceeding without first determining that would satisfy the action is referable to arbitration under Revised Code 2711.02b. It was an abuse of discretion for the court to award sanctions of attorney's fees without the hearing. It was also an abuse of discretion to award attorney's fees because the record lacks evidence that the appellant's motion for default judgment was a willful violation of Civil Rule 11 or that the motion for default judgment was sanctionable frivolous conduct. Frivolous conduct is conduct that's egregious, it harasses and maliciously injures a party. It's not warranted under existing law or can't be supported by a good faith argument for an extension, modification, reversal of existing law, or establishment of new law. There's no mention of the word frivolous in that May 29th order.
No, the court did find there was no basis for filing the motion. Isn't that per se frivolous if there's no basis for filing something? And I appreciate the court never said frivolous. I won't dispute that, but they said there's no basis for filing this.
Right. That kind of touches, I think, on the third criteria I mentioned for frivolous is that not warranted under existing law.
Right.
But we beg to differ that the motion for default judgment is permitted under existing law. The defendant did not file an answer to the complaint, nor a Civil Rule 12 response. They filed a motion in response to the complaint. Civil Rule 54 and 55 explicitly allow motion for default judgment. And a motion to stay is not one of the enumerated Rule 12 responses. And, also under Rule 11, Attorney Dobbins had a good basis to file the motion for default judgment. There's ample case law that the party who seeks to have arbitration needs to do two things. One, file for the stay, and secondly, file a responsive plea. A third assignment of error is that the trial court erred as a matter of law that the motion to stay and request for referral to arbitration under revised code 271102 effectively told the answer requirement of 28 days. Neither the trial court nor the appellees have cited any statute, any civil rule, case law, or other authority that filing the motion to stay automatically exempts a party from filing an answer or responsive pleading. In our briefing, we had cited the 9th District case Alt versus Parkview. In that case, it was noted that under revised code 2711.02b, the trial court must determine that the issue is referable to arbitration pursuant to a written agreement to arbitrate before it may stay proceedings pending arbitration. The court essentially made a new procedure rule when it told the case before it made that decision that it was referable to arbitration. I'd like to reserve the remainder of my time for rebuttal.
Thank you. You will have your full 5 minutes for rebuttal.
Good morning. May it please the court, my name is Adam Lumble. I'm counsel for the defendants in this case, Daniel Core and Candace Co-working and Pop-Up LLC. Before I get into the procedural issues, I would just like to remind the court that this is a $6,050 dispute between Haley Dietrich, who was subleasing co-working space from Candace Co-working and Pop-Up LLC. The underlying building was sold by the owner, and then Candace Co-working and Pop-Up LLC no longer had any space to rent to Ms. Dietrich. And there was a written lease agreement between the parties with a mandatory arbitration provision. Rather than filing for arbitration or even filing a small claims court or municipal court, Ms. Dietrich chose to bring suit in some county common pleas court. And in this case,
She has the ability to do that. She can waive her right to arbitration if she chooses to by filing too, can she not?
she can. Yes, Your Honor. And legally, she was well within her rights to do that. It just seemed like an aggressive move considering the relatively low amount in controversy, given that the state of Ohio set up small claims court, municipal court, and then the common pleas divisions. However, I entered an appearance on behalf of Daniel Core, who had been served, as well as Candace Co-working, which had not been served. The same day I entered the notice of appearance, I filed the motion to stay under the statute. The motion to stay is mandatory. If I had not filed the motion to stay on behalf of my client, we would have waived our right to arbitration and been stuck in court where.
And that's under 271102, I recall, that the statute that requires the filing of the motion for stay?
Yes, Your Honor, it's 271102B is the statute.
Does that statute discuss whether or not that is sufficient of an answer, or does it require, or is it silent on whether you need to do anything else under the civil rules?
The statute itself is silent, and in my research, this appears to be somewhat of a novel issue. I haven't found a case where a plaintiff attempted to default a party who had entered an appearance and filed a motion for a default judgment. So the way the courts have analyzed it is more about filing the request for arbitration too late in the proceeding rather than too early in the proceeding. So the three recognized ways to lose your right to arbitration would be proceeding with the litigation instead of requesting a stay, failing to raise arbitration in your answer, or fail to move for a stay and also file responsive pleadings in the case. So in this case, it was not a mistake that I did not file an answer on behalf of the defendants. It was intentional because under the civil rules, when you file an answer, you also have to file a compulsory counterclaim. In Summit County, once you file an answer or a counterclaim, there's a case management schedule issued. Once the case management schedule is issued, generally speaking, in Summit County, it sets the first pretrial. The case management conference, or the case management schedule, then counts backwards from the first pretrial. You have to do your Rule 26 disclosures. You have to have a 26F conference with opposing counsel and exchange documents, and then you have to attend the pretrial itself.
Do you think you could have moved for leave to file and not had to do those things that you would have had to do once you filed your answer to see how the court's going to rule on your motion for stay?
Potentially, yes, I could have done that. In this case, the court didn't end up ruling on the underlying motion until November, so even the automatic stay available in Summit County would not have been long enough in that case, and then I would have been in the the same position. Do I file the answer, counterclaim, and trigger my participation in the litigation, or do I allow the court time to rule on the stay? I was certainly not anticipating being defaulted when there was a motion for stay pending that Ms. Dobbins had actually opposed and entered into. So with respect to, I guess, the first appeal, 30349, there were the three issues in there about the court's sanctions. I will concede to the court that the case law is clear that an evidentiary hearing does have to be held either under 23-2351 or under Civil Rule 11. The court did not hold an evidentiary hearing. I believe in this case, because the monetary penalty was so minor, it was $150, which is less than a full hour of my time, which was required to respond. I can't speak for the trial court on why an evidentiary hearing wasn't held, but the monetary amount was more or less de minimis at that point. However, the analysis of the court, even though it's not articulated, it can be inferred from the wording of the order. The court found that there was no basis to file a motion for default judgment. The standard under Rule 11 is subjective bad faith. So did Attorney Dobbins herself believe that she had a good faith standard or a good faith basis to file this? And I would submit that she did not. The same day that she filed the opposition to the motion to stay, she filed a motion for default judgment. She did not mention that there was a pending motion. She made it seem as if my clients were in default. The answer had not responded in any fashion. She also attached a proposed order to her motion for default judgment, which again, generally speaking, if a proposed order is for something you'd expect to be signed off on immediately, not contested.
Well, going back to the issue of, you seem to be alleging that Attorney Dobbins misled the court when she filed her motion for default judgment in some regards.
Yes, Your Honor.
The court, in its findings on the order on the 28th, talked about no basis, did not discuss if there was any, in the court's view, misleading of the court. Is that fair to characterize the court's order, that they never said the court never found there was any misleading the court?
Yes, Your Honor. That's fair, and I apologize if I'm
It's okay, I just want to make sure I understand the order correctly.
Yes, so the
You
order...
can argue that, but the court did not find that.
Correct. And then the other, so I moved for the motion to be stricken and moved for sanctions on Civil Rule 11 and 23-2351. So Civil Rule 11 is a subjective standard. 23-2351 is an objective standard. So whether there is an objectively reasonable basis to file something with the court, and it seems more likely that the trial court found that there was not a basis under 23-2351 for filing a default judgment under these circumstances, because there was a motion to stay and refer to arbitration pending. So it's my belief that based on the wording of the order that there was no basis, it's likely that the sanctions were awarded under 23-2351 based on the circumstances. With respect to the tolling of the agreement, there is, counsel is correct, there is no statute, there is no civil rule that provides for that. It does seem to be a void in the rules or in the law, because under the case law from the Ohio Supreme Court and other appellate courts in the state, the longer you stay in the litigation, the more you participate in the litigation, the higher likelihood of the opposing party saying that you waited too long, you didn't ask for arbitration soon enough, and now you've lost your right to arbitrate. And what the case law doesn't talk about is filing for arbitration too soon. So in an abundance of caution, we filed for arbitration immediately and nothing else, because I did not want to file an answer, a counterclaim, and then start participating in the early stages of Rule 26 discovery. And I believe that the judge's analysis was correct, that there is an effective tolling that happens once a party requests its arbitration, as it's required to under 271102B. And I guess briefly, with respect to the second appeal that was combined with this appeal, I just had two brief comments on that. the appellant's first argument has to do with the trial court not properly applying the full scope of the civil rules, which I don't believe to be the case. I believe the court did apply the civil rules. The complaint was filed, the motion for a stay and referral to arbitration was then filed under the statute, and then the court, again, the court effectively told it because the defendants had no other choice other than to do what they did. And then there's an important point in the second appeal. The appellant conflates being in default of the civil rules, which they're arguing by not answering that my clients were in default of the civil rules, with being in default of arbitration. Those are two different things. Being in default of arbitration means you participated in the litigation, you didn't ask for arbitration, and now you can't because you went too far down that road. Being in default of the civil rules means that you didn't file an answer or otherwise respond to the complaint. In this case, we were not in default of arbitration. The only thing that defendants did in this case was file a notice of appearance, file a request for arbitration, and there's no possible way we could have been in default of arbitration. With respect to being in default of the civil rules as it relates to answering the complaint, again, we did not file an answer by design, but we did appear and respond. We were not disregarding the judicial system and ignoring the summons and complaint that was served on my client.
Now, when one of your clients was served, the other client ever been served?
The other client was served later. They
Been served as of, okay.
Yes, I believe Mr. Core personally was served on April 1st. Then the LLC, Ms. Dobbins actually went through the mechanism to serve the Secretary of State to obtain service on the LLC sometime about 5 weeks later. Unless there are any questions from the court, I would respectfully request that the court overrule both of the appellant's appeals and, to the extent necessary,
So you acknowledge the court did not have a hearing as required to make the determination of sanctions in either case. Do you still, based upon that, still believe that this matter should not be reversed since the court failed to make the proper findings?
That occurred to me as I was speaking, that I would ask the court to overrule in part the appeals, and then to the extent necessary to comply with either Civil Rule 11 or 23-2351, order that the trial court hold an evidentiary hearing to determine the appropriateness of the monetary sanction imposed. Thank you.
Thank you.
Parties agree on at least 2 points. One is that filing suit by Haley Dietrich waived her right to arbitration. They also agree that before a court imposes sanctions with an award of attorney's fees, a hearing needs to be held. Mr. Runkle just conceded that in his argument. When the defendant, Cora, was served with the complaint, the appellee is concerned that they had to file an answer, and if they did that, there would be a compulsory counterclaim. Well, you're not required to file an answer when you get served with a complaint. You can file a Civil Rule 12 motion to dismiss or other Rule 12 grounds. So you didn't have to file an answer until the court rules on that Rule 12 motion. An answer is not required. So they did have the option to, when they filed the motion today, to seek the other part of their, that they're required to do in addressing a complaint is to file a responsive plea. They only did half of what they're supposed to do. They only filed the motion to stay. They didn't do the other part, second step of filing a responsive pleading. Before a court awards sanctions, there has to be a hearing, and that hearing is in accord with Civil Rule 11 and the statutory requirement under Revised Code 23-23.51. We submit that Attorney Dobbins had good grounds for filing that motion for this default judgment. There was no timely responsive pleading filed. Civil Rule 54 and Civil Rule 55 explicitly permit a motion for default judgment. Attorney Dobbins also have good grounds following that motion.
Let me ask you this, Councilor Appellee suggests that in the second appeal, you're arguing that they're in default for asserting their right to arbitration. Are you attempting to argue that in the second appeal and not merely that they're in default for not following the civil rules and filing an answer or some other responsive pleading?
Well, there are two components to that. One is that the appellee did not file an answer or responsive plea. So under civil rules, it's our position that they are in default. Secondly, at the time that the trial court issues May 29th order, there's been no determination yet that the matter was referable to arbitration. That wasn't made until November.
But they've asserted their right to a timely effect arbitration under 271102. Would you concede that point?
Half of it. They filed the motion to stay, which is one of the requirements under the statute to request arbitration. But the other component of that motion to stay, in response to being served with complaints, they also had to file a responsive plea. And
Well, I think Counsel for Appellee is separating that out. There's right to arbitration that they assert by 271102, and then there's did they file some answer or otherwise under the civil rules. And they're saying, look, we understand the argument for civil rules, but we didn't do what we're supposed to with civil rules, but certainly we, by acting under 271102, did not waive our right to arbitration. Do you agree that they did not waive their right to arbitration in this case? Go ahead.
No, we don't agree at that point because they didn't comply with the overwhelming case law that says it's a two-step process to request arbitration. You need to file a motion for stay, which is what they did. But they did file a responsive plea. Because of that, they're not in default of the civil rules, but also in default of the request for arbitration. The court exercised abuse of discretion by awarding sanctions of attorney's fees without the hearing. It was also abuse of discretion to award attorney's fees because the record lacks evidence that the motion of default judgment was a willful violation of Civil 11, as well as Civil 11, the frivolous conduct statute. Because the trial court failed to conduct an evidentiary hearing, the record does not support any award of sanctions. The trial court abused its discretion to award sanctions without first holding a hearing, determining there's a willful Rule 11 violation, and there's no explicit finding by the trial court of frivolous conduct under revised code 2323.51. Court erred as a matter of law in filing the motion to stay and request for referral to mandatory arbitration tolls Rule 12 cancel period. We request that the court sustain our 5 arguments and assignments of error and reverse the May 29, 2022 order and reverse the November 29, 2022 order. Thank you.
Thank you, Counsel. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it is released, and it will be posted on the Ohio Supreme Court website. Thank you for your time.